Could use of a racial slur, like the N word, one time by a coworker be enough to create an actionable case of harassment? I'm Karen Michael, and you're listening to The Job Judge. Welcome to The Job Judge, the podcast for anyone who works. I'm Karen Michael, your host of The Job Judge. We're together every single week. We navigate through all those legal landmines and workplace dysfunction that's probably happening in your organization. A couple ground rules before we get started. I am an employment lawyer, but I cannot give legal advice on the podcast. It is truly just general guidance. And also, we do talk about sensitive subjects on this podcast, including today. So just a forewarning. Finally, you're not going to want to miss an episode. Go ahead, click that subscribe button, like, subscribe, follow along so you don't miss an episode. Let's talk about this case. So there was a case that was filed in the state of California under California law, but the case has more broad applicability because it applied the same standards as they would under Title VII of the Civil Rights Act, which is the federal employment discrimination law that prohibits discrimination or harassment based on race, gender, national origin, color, and religion for employers that employ 15 or more. So that's why this case is relevant. And let's talk about what this case is about. The case is Tawanda Bailey versus San Francisco District Attorney's Office, and she sued other defendants as well. And just by way of background, the case started out in the lower court, got appealed to the appellate court, and now this case on July 29th, 2024, the Supreme Court of California decided this case. And so that's why it's really relevant, and it talks about the case from beginning to end. That's what we're going to do. Here's how the case begins. Plaintiff Tawanda Bailey sued the San Francisco District Attorney's Office, among other people, under the California Fair Employment and Housing Act. And what she alleged is that she, an African-American woman, alleged that a coworker with whom she shared an office and job duties called her the N-word. She further alleges that after she reported this incident, the human resources manager for the district attorney's office obstructed the filing of a formal complaint, engaged in a course of intimidating conduct, and ultimately threatened her that she was, quote, going to get it. Bailey's action against the city alleges she was subjected to racial harassment by her coworker and retaliation by the human resources manager after complaining of the harassment. Human resources gets a bad reputation. Many times it's not really deserved. I think human resources generally does a very good job. In this case, I've got some criticism for how human resources handled the situation. The trial court, so it goes to the initial court, and the initial court, the trial court, granted what was called summary judgment for the defendants, for the city, finding that Bailey failed to make a prima facie case showing that there was a violation of the law. So basically, she lost. Not enough to even go to trial. She appealed. On appeal, she lost. Again, not enough even for you to go to trial on this. It then goes to the Supreme Court of California. And this is what the court said. This case asks us to assess whether certain conduct may be actionable under the law. First, we assess whether a coworker's one-time use of a racial slur may be actionable in a claim of harassment. That is, whether such an incident may be so severe so as to alter the conditions of employment and create a hostile work environment. For the reasons discussed below, we conclude that an isolated act of harassment may be actionable if it is sufficiently severe in light of the totality of the circumstances and that a coworker's use of an unambiguous racial epithet, such as the N-word, may be found to suffice. The second thing that the court looked at was whether a course of conduct that effectively seeks to withdraw an employee's means of reporting and addressing racial harassment in the workplace is actionable as a claim of retaliation. That is, whether such conduct may constitute an adverse employment action by that human resources person. The court concluded that it may. So in this case, the employee didn't necessarily win the case, but she won enough to at least go to litigation, go to trial, and let a fact finder decide the case. Let's talk about what these rules are and hopefully understand the narrative of how behavior in our workplace impacts so many other people and why it is so important to make sure that we have an environment free from these kinds of behaviors. This is how the case goes. Miss Bailey, began working in the district attorney's office in 2001 as a clerk in the records department. The office promoted her in 2011 to an investigative assistant position. She worked alongside a woman named Miss Larkin, who was another investigative assistant. The two sat next to each other in the records room. Again, she is African American. Larkin is Fijian East Indian. Now, all of these allegations initially arise out of an incident that happened in 2015. So it's been 9 years. This case is still in litigation, and now it's got to go back to trial. That alone should tell you how disruptive it is to have this nonsense happening in our organizations. I promise you, prevention is so much better than reaction. Preventing these behaviors, setting the expectations, making sure everybody knows what the rules are so that ahead of time, we can make sure people don't do things like what allegedly happened in this case. According to the case, on January 22nd, 2015, while in the records room, Larkin told Bailey, the plaintiff, that she saw a mouse run under Bailey's desk. Bailey was startled and jumped out of her chair. Larkin walked up to Bailey and quietly said, quote, "You N-words is so scary." And she used the N-word. Didn't say N-word. She actually used the N-word, which I will not use on this podcast. Immediately following this incident, Bailey left her office and told 3 coworkers what Larkin said. That's very relevant when I'm doing an investigation, when somebody immediately after an incident describes that incident to somebody else, their demeanor and how they describe it. They tell somebody right away. I had a case recently where as soon as something happened to this employee, she immediately went outside and called her friend, and I had her phone record to show that she spent 30 minutes on a call with this person. So that is relevant when somebody immediately tells somebody as to whether or not the information is credible. It's not dispositive, but it's certainly relevant. Bailey was crying and upset. Although she was offended by Larkin's use of the racial slur, she did not immediately complain to Human Resources because she feared harassment and retaliation. And oh, by the way, that's what she claims exactly did ultimately happen. The fear was based on her understanding that other employees had been harassed and discriminated against following incidents with this coworker, Larkin. Specifically, the plaintiff understood that Larkin was best friends with the office's department personnel officer. See, that's a problem. And I hear this a lot, by the way, where either it's in rumor or in fact that HR is too close to somebody in the organization. When we are in human resources, we cannot be best friends with other people in the organization. We have to stay objective. And if we feel that we can't make an objective decision based on different things, then we should not be working in human resources. Human resources carries a very important position of trust, and it gets a bad reputation because some people go into human resources not because they want to do it as a profession, but potentially just because it seems like something that they maybe are a people person and they want to help people or whatever the reason. Good intentions, but human resources is a profession that requires a lot of objectivity. And frankly, it's kind of lonely in human resources. And that's kind of the way it should be, because we have to make sure that we step aside our personal opinions about things and people and issues, etc., and maintain that objective standard. Sometimes that doesn't happen, and that's one reason why human resources doesn't get the best reputation. The employee believed that Larkin's actions against other African-American women also were supported by this human resources person, and that there was some negative response to the employees that complained about Larkin because of this human resources person. So she didn't complain initially to anybody in human resources about the N-word being used in her presence initially. But on January 23rd, shortly thereafter, at an off-site party, Bailey's supervisor overheard a conversation about the incident between Bailey and Larkin. The supervisor told Bailey she planned to notify human resources. Bailey felt more comfortable with the supervisor reporting it rather than doing so herself. Stop there. Check, check, check to the supervisor. Good job. That's exactly what you should be doing. The supervisor overheard something that the supervisor knew would be something that would be a reportable incident. And the supervisor did exactly what we need our managers to do. Report it. That's exactly the right thing. And even if Bailey didn't want the supervisor to report it, the supervisor still had a duty to report it. There was not a formal complaint. The employee had not complained to the supervisor, and none of that mattered. The supervisor overheard that there had been a possible violation, and then the supervisor took action. Then, shortly thereafter, on January 28th, the supervisor reported the incident to the Assistant Chief of Finance Administration. They then conferred with a bunch of other people who reported it to the district attorney, and they agreed that they would meet with her separately. And this personnel officer that was the subject of the retaliation attended the meetings. They all met with Bailey on January 29th, which is great. Day after, all right, everything's moving along exactly as it should. Bailey reiterated that Larkin had used an offensive racial slur and had confirmed this was the only time she had heard Larkin use such language. They were informed that management would address the issue and that Bailey should report any inappropriately behavior directly to management. They then met with Larkin, who did not admit to making the alleged remark. The Larkin was counseled on the city's harassment-free workplace policy, and she was informed of the alleged language was unacceptable. Larkin asked if Bailey filed a complaint and was told that no complaint had been filed and no further action was taken against Larkin at that time. Stop there. Wrong answer. We put all this emphasis on whether a complaint was filed. It's not a complaint-based system. It's a notice-based system. So if your process in your organization requires that there be a formal complaint filed before something is addressed or investigated, that's a bad system. Don't have that system anymore because that's not a best practice system. What's interesting is Department of Human Resources, the big Department of Human Resources in this organization, did finally do an investigation. And they sent Bailey a letter regarding her complaint. The letter stated that based on the information provided, Bailey's allegations were, quote, insufficient to raise an inference of harassment, hostile work environment, or retaliation, and therefore the department would not investigate her complaint. I don't understand why you do an investigation to decide whether you're going to do an investigation. Here's an idea. Just do an investigation. Why are we investigating to decide whether we're going to investigate, whether there's sufficient information to investigate? What a ridiculous process. I mean, just investigate. This is not that complicated of a situation, by the way. You could probably investigate this situation in like a day or two. This is not some, 15 witness issue. What is going on here? The level of lack of skill that I see sometimes in our HR departments, it is a little surprising. While DHR acknowledged the extreme offensiveness of the N-word, it stated that one comment was insufficient to create an abusive working environment. Why are you even rendering that conclusion? This employee is telling you that she felt this was an abusive working environment. We don't need HR determining what the law would say. We need HR to just apply their policies. And use of the N-word in any workplace that's civilized would say that that behavior is completely unacceptable. And at a minimum, a first and final warning should have been issued to that employee, if not termination. So the test in this case, and I'm just going to focus on the harassment issue, not necessarily the retaliation question, even though it's clear that there would be some sort of allegation of retaliation that would probably be able to go to litigation, which it will. But to just understanding what is illegal harassment, the harassment must be unwelcome. And in this case, because of race. That's the first two parts of the test. And the court said, check, check, that's easily met, no question about it. But the next part of the test is whether it is severe or pervasive. And the law requires that the harassment be severe or pervasive in order to count for a hostile working environment and to be harassment. And as the court noted, the standard for workplace harassment claims strikes a middle path between making actionable any conduct that is merely offensive and requiring conduct to cause a tangible psychological injury. Simple teasing, offhand comments, and isolated incidents, unless extremely serious, are not sufficient to create an actionable claim of harassment. And so the question is, here it is, just one allegation. There was one racial slur used. And according to the argument by the city, a single race-based comment by a coworker, and they really focused on the fact that she was a coworker. She wasn't a supervisor. She was just a coworker. She didn't have any authority over her. Their argument was one incident by a coworker clearly is not enough to rise to the level of severe or pervasive. The plaintiff disagreed, and she was correct, according to the court. The objective severity of harassment should be judged from the perspective of a reasonable person in plaintiff's position, which is a very interesting analysis. And the court, the Ninth Circuit Court of Appeals, said racially motivated comments or actions may appear innocent or only mildly offensive to one who is not a member of the targeted group, but intolerably abusive or threatening when understood from the perspective of a plaintiff who is a member of the targeted group. I see this frequently when I do training. If I talk about religious discrimination or harassment or national origin or sexual or disability or age, if you're not in that group, it might not hit as hard. But when you're part of that group that it's coming after, it does feel different. That's why one of the things I talk about in my workplace conduct training that I do, I'll talk about the fact that harassment's in the eye of the beholder. We can all look at the exact same set of facts, and because of our life experience, because of things that we believe in, because of our own characteristics, we might view things differently. The court said, we must therefore consider allegations of a racially hostile workplace from the perspective of a reasonable person belonging to the racial or ethnic group of the plaintiff. The court said this allows us to recognize forms of discrimination that are real and hurtful and yet may be overlooked if considered solely from the perspective of an adjudicator belonging to a different group than the plaintiff. And so the court noted and agreed with other circuits in the country that a single racial epithet can be so offensive it gives rise to a triable issue of actionable harassment, meaning let a jury decide it. Don't let a judge decide this as a matter of law. The court said, although viable hostile work environment claims often involve repeated conduct, it is not required. The foundational high court standard provides that actionable harassment must be sufficiently severe or pervasive to alter the conditions of the victim's environment and create an abusive environment. The test set forth by the Supreme Court is whether the alleged conduct is sufficiently severe or pervasive. It's an or test. It's not an and test. It can be severe or it can be pervasive. This standard, the court said, allows an isolated incident of harassment, if extremely serious, to create a hostile work environment. So there you have it. We now know And we've kind of known this for a while based on other circuits, but in July of 2024, it's been reaffirmed a single incident can create a hostile working environment or can form the basis for that. And so now this case is going to go to trial on whether or not that single incident, as well as whether it can be imputed onto the organization, meaning the organization knew that it happened and didn't do enough to stop it. It's now going to go to a jury. So that's the test. The advice that I give to employers is create an environment where this kind of behavior doesn't happen. And you do that by creating the policy, distributing the policy, engaging in training for your employees. Again, call me. I say this frequently. I'm happy to parachute in and do a training for your organization, your managers, your employees, and we explain what the rules are, because a lot of people don't understand what the rules are. And then as soon as you know something's happening, just like that manager did in this case, report it right away. And don't allow HR to be in a situation where they're the ones retaliating against an employee who complains. That's just unheard of and completely inappropriate. And then take firm action against anybody who may have violated your policy. Because you see here, this is a 9-year litigation going on over this incident that could have been resolved pretty quickly, right away, not a complicated situation, with some basic human resources and management practices. And now it's time for Ask the Job Judge, where every single week I read either something that's on social media, a question asked in human resources. I get an email. You can email me at Karen@thejobjudge.net, or I might read something that's on my Instagram or TikTok page. You can follow me there at the Job Judge, and I get asked lots of questions on there. But this one really struck me. It's on Ask HR from Reddit, and it really struck me, this question. And it's a little long, but I'm going to read it anyway. This person says, should I, a 27-year-old female, report my coworker, a 56-year-old male, for his behavior? The punchline is absolutely, because this man is a sexual predator, but I'll read to you what she said. I work in healthcare at a small clinic where I've formed a friendship with an older coworker, Bob, who claims to be married to a woman overseas, though I've never seen any pictures of her. Over time, Bob began inviting me out more frequently, especially after his other friend at work left the company. I went to a bar with Bob and our former coworker without my husband and noticed that Bob talked about women he was currently dating, which I found odd given that he claimed to be married. One evening, I went to a bar with Bob alone, and after just a couple of beers, I started to feel unusually unwell. My head was spinning and I felt disoriented. Bob began asking very personal and inappropriate questions, particularly about my marriage and sex life, which made me uncomfortable, but I found myself answering because I felt so out of it. Later, I ended up in my car with Bob, where things took a darker turn. He became increasingly inappropriate, smacking me when I moved to the front seat and touching me without my consent, including massaging my neck and legs. Gross. When my husband called, concerned, Bob tried to throw my phone out the window and insisted on taking me to his house, but I refused. Eventually, Bob drove me home, and instead of taking me straight there, he drove around the block several times, muttering about my husband being on the porch. My husband kept calling, but I was too distracted to notice half the time. When we finally arrived, my husband thought I looked off and suggested calling the police. Bob freaked out, insisting I was just drunk. After my husband drove Bob back to his car, I went to the hospital where a forensic nurse suggested I may have been drugged. The next day, Bob continued to call and text me, downplaying what had happened and even implying there could be a next time. Now I'm questioning whether I'm overreacting and trying to figure out what to do next. Now, I don't want to hear one person on this podcast ask, well, why did you go to the bar with him in the first place? Why are you even with him alone? People try to make friendships, and a man and a woman can be a friend at work. This is not her fault. This is Bob's fault. Bob is a sexual predator. And what happens outside of work, if that impacts at work, the Equal Employment Opportunity Commission refers to that as the extended workplace. And what happened out there between her and Bob is definitely going to impact the job. So she absolutely needs to report it. And what I want her to do is make sure that she's saved everything, saved the text messages, saved the phone calls, even if you have to get the medical records, even though that's personal to you, that may show that you were drugged. All of this behavior is, of course, going to make a reasonable person uncomfortable. This man's behavior is unacceptable, and you should not feel bad one bit about reporting him because his behavior is unacceptable. And it is reasonable that you feel that you are uncomfortable in this work environment. Asking you about your sex life, your personal life, all of that is nothing more than grooming, which some of these sexual predators do. And I see it in our workplaces too often. And too often people feel guilty reporting it. No. But please go and tell somebody right away in human resources so that you can make sure that this never happens again. Now, you don't want to miss an episode of The Job Judge, so be sure to like, subscribe, follow along so you don't miss an episode. I'm Karen Michael, and you've been listening to The Job Judge.